The police will often lead you to believe that if a complaint has been made of rape or a sexual assault, they've got the signed statement from the complainant, therefore you must have committed the offence. That's not correct. You've got every right to defend the case. We as solicitors, we see these cases day in, day out, and we know, and there's been lots of case studies, there's been lots of psychological studies as to why people will make false allegations. And we're seeing an ever-increasing number of false claims being made. I'm not saying every case is wrong, I'm not saying every person is innocent or guilty, but it needs looking at on each individual case. One thing that I sometimes refer to is a case I dealt with a number of years ago now, many years ago, with a young client of mine who was charged with 7 counts of rape. And this might illustrate some of the issues that need looking at. He was arrested, he was investigated, eventually charged. I didn't think the evidence was very strong. We made representations to the prosecution that he shouldn't be charged. But at that early stage, as defence solicitors, we get to know relatively little about the evidence. The police will keep everything to themselves. There's no obligation on them giving evidence to us. We don't see any reports, we don't see statements. They can keep everything to themselves. In that case, my client was charged with 7 counts of rape. Once he was charged, we were then entitled to see the evidence. When we got to see the evidence, there's a number of concerns that I had as to how accurate that evidence was, but also the credibility, the believability of the complainant. It was a young girl who was known to him, known to the family, who was making the, what I would suggest were false, clearly false allegations. As we did more work and investigation work, we had the belief that she had serious mental health issues. Now, we as solicitors did not have the right to simply request somebody's medical notes or mental health notes. We're just not entitled to do that. But what we can do in certain circumstances, where we believe this might have an impact on the case and the fairness of the case, is we can ask the prosecution service to obtain those medical notes or the mental health notes, to review them fully themselves, and then to disclose to us anything that it could impact on the case, anything that could assist the defence. And in that case, we did make those representations to the prosecution. They did, to be fair to them, they did agree and they obtained those records. They did then review those records, and further, they did then disclose certain records to us. And what we found out was startling. We found out, for example, that the young girl concerned had a propensity to tell lies. She'd make up stories. This was known because it was documented with her therapist. And those lies could be anything, new hairdo, won the lottery, whatever it might do. But that's important from a defence position, because if somebody has a willingness to tell lies about something, well, where do you draw the line? It affects their credibility. We also found out that she'd made previous false allegations of a sexual nature against other men. We also found out that she'd made a previous false allegation leading to the arrest, to the charge, to the prosecution of another man who went all the way to trial for an allegation of rape and was found not guilty. And then a number of months later, the allegation was made against my client. Despite all of this, and despite us making representations to the prosecution that the case should not proceed because there was not, in my view, a reasonable prospect of a conviction, for some reason, the prosecution felt it was right to continue that case. And it led eventually, it took 2.5 years, but it led eventually to going all the way to a trial by jury. It was a 7-day trial. I was there throughout, and it took the jury 20 minutes to find my client not guilty of all 7 charges. One of the quickest jury decisions ever known, certainly I think the quickest one I've ever experienced. And it sort of illustrated to me the problem with the society, the problem with the setup we have at the moment, where people can be accused of rape on very, very flimsy evidence, in my view, who should not be charged, should not be prosecuted, but who nowadays are being prosecuted. And that was a number of years ago. Over the years, it's actually got worse. I'm seeing more and more people being prosecuted on very poor evidence, who, in my view, should not be prosecuted. And so I think we need to weed out those genuine cases, people who have been assaulted, to those where allegations are being made because they may have mental health issues, because of the Me Too movement, because of what's on the internet, because of wanting to get more likes on social media with their friends. to want to be have more attention from people. There's lots of known reasons now as to why people will make false claims. But when somebody is facing a long period of time in prison based on a false claim, that needs dealing with very, very carefully. So if you are under suspicion, if you've been arrested, if you've been charged with a sexual assault or a rape allegation, please get in touch, because there's lots that needs working on. And the sooner we can work on it, the more helpful that is from me, from you, from everybody involved, to try and resolve without it leading to a trial. If it does go to a trial, we've got to win that case, because a conviction can lead to a long time in prison. So please get in touch for a free consultation.